Hello dear students, welcome you on General Study Preparation YouTube channel. Dear students, today we'll discuss about the fundamental right. This is very important topic for all kinds of competitive examination. If you are preparing for HPS, Allied Service Exam, Naib Tehsildar, TGT Arts, PGT, Political Science, Public Administration, Economics, then definitely you will get lots of information, lots of knowledge from this lecture. If you are preparing specially for polity and economy, then we will deliver special kinds of lecture to you on this YouTube channel, and you have to subscribe and like share this video. So fundamental right, what is the fundamental right? If we'll talk about the fundamental right, it is mentioned in the part 3 of the Constitution and under Article 12 to 35. So fundamental rights means the rights which are necessary for the development of the public or the people or an individuals. So development of the personality of every individual and to preserve human dignity. That's why the fundamental rights are very necessary. All people, irrespective of race, religion, caste, or sex, have been given the right to move the Supreme Court and High Court for the enforcement of their fundamental rights. And there are 7 categories of the fundamental rights which are covered from Article 12 to 35. But here you have to remind that now we have only 6 fundamental rights. One fundamental right has been removed from the list, and now that has been made as legal right, and that is right to property, and that is now mentioned under Article 300A. So this is all about the introductory part. Now we'll go with the definition. What the definition say? Definition says that the states. What is the states? In the Article 12, that is the mention of states. What is meant to the state include governmental and parliament of India and the government and the legislature of each of the states and all local and other authorities within the territory of India or under the control of the government of India. It means that all governing bodies is irrespective of, that is at the central level or state level or local level, are considered as the state under Article 12. So Article 13, now Article 13 says that laws inconsistent with or in derogation of the fundamental rights. Article 13 has defined that any kinds of law made by the parliament or the governing body of the country, if that is derogatory or inconsistent with the existing law of the country as well as the law what are against the individual's dignity, then that are void on the days it made enforceable. So state shall not make any law which takes away or abridge the rights conferred by the this part, and any law made in contravention of this clause shall to the extent of the contravention be void. This is written under Article 13. Next, we'll go with the Article 14. Article 14 says that it is the right of equality before law. Every citizen under the eyes of law are equal. There are 2 kinds of power under Article 14, that is equality before law and equal protection of the law. Every person, all individuals, irrespective of their caste, creeds, place of birth, age, they are considered equal in front of the laws. But if it comes the part of protection of the law, then it is also equally protected to the all individual, irrespective of their position, power, caste, place of birth, power. Everything is excluded, and only one thing that is included, that is equalization, equal treatment to all citizens of India under Article 14. Next, Article 15. Article 15 says that prohibitions of discrimination on ground of religion, race, caste, sex, or place of birth. Every kinds of discrimination on the following grounds has been removed by inserting the article of 15. If any person found to exercise such kinds of discrimination on the ground of religion, race, caste, sex, or place of birth, then they are liable to do the action against this activity. So, no, here is mention of that no citizen shall, on ground only of religion, race, caste, sex, place of birth, or any of them, be subject to any disability, liability, restriction, or condition with regard to access to the shop, public restaurant, hotel, and place of public entertainment. And second, the use of wells, tanks, bathing ghat, roads, and place of public resort maintained and wholly or partly out of state fund or dedicated to the use of general public. Nothing in this article shall prevent the state from making any special provision for the women and children. This is also mentioned under Article 15, Clause 3 that if states consider that they need to make special laws for the women and children to protect their right, then they can do that also. And Clause 4 also says that in this article in clause 2 or article 29 shall prevent the state from making any special provision for the advancement of any socially or educationally backward classes of citizen or the scheduled caste and scheduled tribe. If the backward classes as well as other peoples who are socially or educationally backward, they can, then the government can form such kinds of provision or such kinds of laws which will make their representation adequately in the eyes of law. So this was the Article 15. Now we will move with Article 16. Article 16 says that equality of opportunity in matters of public employment. Every person should get equal chance to get the employed. So, no citizen shall, on ground only of religion, race, caste, sex, descent, and place of birth, residence, or any of them, be ineligible or discriminated against in respect of any employment or office under the state. If state is running or financing any kinds of office, then there the opportunity to get employed will be equal to every citizen, irrespective of their religion, race, caste, sex, descent, place of birth, and residence of any of them. So nothing in the article prevent Parliament from making any law. It is also mentioned that Parliament can make special provision for the backward classes or scheduled caste and scheduled tribe classes if they are not adequately represented or they are not adequately getting employment opportunity to get employed in the government offices. So next is nothing in this article. This is article clause 4 subclause A of Article 16 that nothing in this article shall prevent the state from making any provision for reservations in a matter of promotions of any class or class of post in the services under the states in favor of the scheduled caste and scheduled tribes, which in opinion of the state are not adequately represented in the services under the state. Here, you have to understand that SC, ST, if the government or the state consider that they are not adequately represented, then the state can freely make any special kinds of provision for their promotions in their jobs. So this is mentioned under Article 16, Clause 4, Subclause A. So nothing in this article shall also affect the operations of any laws which provides that the incumbent of an office in connection with the affairs of any religious or denominational institutions or any member of the governing body thereof shall be a person professing a particular religion or belonging to a particular denomination. So next is Article 17. Article 17 says abolition of untouchability. Earlier, before the independence 1947, there was a tremendous untouchability phenomena in our country, but later on it was considered as the discrimination against the human dignity if any person found to do such kinds of activity surrounding, then they will be obliged for certain legal action. So here is the untouchability is not kinds of things that should be in the practice. Here is the word untouchability is not defined in the constitution. It refers to social disability arising due to birth in certain class or caste. Parliament is authorized to make laws for punishment on violations of this right of people or to save people from offense of untouchability. In exercise of this power, Parliament framed Untouchability Offense Act 1955. This act has been amended in 1976 and renamed as Protection of Civil Rights Act 1955. So, Protections of Civil Rights Act 1955 defines certain acts as offense under untouchability. First is denying access to shops, public restaurant, hotel, place of public entertainment, use of reservoir, taps, or other source of water, road, etc., denying the right to worship on account of one's caste or religion, denying admission to any person to public institution, hospital, educational institution, etc., preaching and justifying untouchability, insulting the scheduled caste member on ground of one's caste or making derogatory remarks. A person convicted of offense of untouchability is disqualified. This is the main point, is disqualified for the elections of union and state legislature. This is mentioned under the article 17 or in reference with the Protection of Civil Rights Act 1955. Now, next is abolition of title. Earlier, it was very popular in the British era that they used to give some special kinds of title to the peoples of the country. That Raja Rama Mohan Roy or Bazir or lots of kinds of titles was given at that time, but now it has been abolished. So no title not being a military or academic distinction shall be conferred by the state. State will not give any kinds of title to any citizen. So if a person wants or won any kind of special title from the foreign country, then they also need the consent of the president, any title from foreign states. Is it clear? So there is the abolition of title under Article 18. Under Article 19, There is the protection of certain rights regarding freedom of speech. We have gotten the right of freedom of speech. We can speak anything, but we have to remind that anything that is against the dignity of individual as well as of in respect of the nations, then that is infringed. So under article 19 clause 1, all citizens shall have the following right to freedom of speech and expression, to assemble peacefully and without arms, to form association or union, to move freely throughout the territory of India, to reside and settle in any part of the territory of India, and to practice any professions, to carry on any occupations, trade or business. And next clause 2 says that nothing in clause A of clause 1 shall affect the operation of any existing law, to prevent the state from making any law insofar as such laws impose reasonable restriction on the exercise of the right conferred by the said subclause in the interest of the sovereignty and integrity of India and security of the state, friendly relation with foreign state, public order, decency or morality, or in relation to contempt of court, defamation or incitement of an offense. It means that if a state consider that a person is doing any kinds of action what is against the integrity of India, security of the state, friendly relationship with the foreign states, then they can impose some certain kinds of reasonable restriction on that persons if they are found to do derogatory activity or the activity what being considered as the loss of one's interest. So next says that these all are now reasonable restriction. Clause 3 says that subclause B of the said clause shall affect the operations of any existing laws insofar as impose or prevent the state from making any law imposing in the interest of sovereignty and integrity of India, public order, reasonable restriction on right conferred by the said subclause. Similarly, in the 4 subclause C, for every things whatever we have gotten here, A B C D E F, these are certain kinds of freedoms of speech, expressions, and peacefully assembling, but there is also reasonable restriction. For this also reasonable restriction, for also this there is reasonable restriction. You can move freely throughout the territory of India, but you can't make any kinds of chaos for the safety of any individual. So you can't move into the other person's room, offices unnecessarily. By using that, I have the right of moving freely throughout the India. So this is the reasonable restriction to reside and settle in any part of the country, but you can't capture the individual property of the other person. So this is also important that there is some certain kinds of reasonable restriction what are being discussed in the following slides, what we have not reading now, because I have explained this. This is not a very big deal to understand these reasonable restriction. Reasonable restriction simply means that you are restricted to do unnecessarily activity or the activity what is against to the dignity of individual or the safety and safety for the safety of the country. So next is protection in respect of convictions or for offense. No person shall be convicted of any offense except for violation of law. You can't make a person convicted for anything. Only and only the person is convicted if he has done any kinds of offense that is against the laws of the country or is mentioned under the certain laws as the offense. So, force at the time of the commission of act charged as an offense not be subjected to penalty greater than that which might have been inflicted under the laws in force at the time of the commission of the offense. So, no person shall be prosecuted and punished for the same offense more than once. If a person has punished for certain kinds of offense at a time, then he would not be punished or prosecuted again for the same kinds of action. No person accused of any offense shall be compelled to be a witness against himself. This is also important point in subclause 3 of Article 20. 21 says, this is the right to education. The state shall provide free and compulsory education to all citizens, all children of the age of 6 to 14 years in such manners as the state may by law determine. There is compulsory education for every children the age group of 6 to 40. This is the right to education. This is called right to education. And 86th Constitutional Amendment Act 2002 inserted Article 21A in Constitution making the right to education RTE, and it provides that 6 to 14 years of age as the fundamental right, and it also added the fundamental duty in Article 51A as 11th fundamental duty, which reads as, it shall be the duty of every citizen of the India to provide opportunity for education to his child or ward between the age of 6 to 14 years. Parliament enacted Right to Education Act 2009, which ensured that every child is provided compulsory elementary education of satisfying quality. This is mentioned under Article 21A. And 21, now we are going to discuss that Article 21. We haven't discussed Article 21. 21 reads as, no person shall be deprived of his life or personal liberty except according to the procedure established by the law. So, under Article 21, this is mentioned that protection of life and personal liberty. So, it is that this article provides that a person can be deprived of his life and personal liberty based on law, but this right cannot be violated without support of any law. No arbitrary actions of executive can violate life, right to life and personal liberty. So implicit right under right to life and personal liberties are some like that: right to health, right to shelter, right to livelihood, environment, medical confidentiality, sexual harassment, right against sexual harassment, right against bonded labor and rehabilitation, right to legal aid and fair trial, right to custodial death and medical care, right to speedy trial, right to dignity, and right to privacy. These are some fundamental rights under Article 21. So, next is Article 22. We'll go with the Article 22. Article 22 says that protection against arrest and detention in certain cases. There is also a very good fundamental right for any unnecessary arrest and detention in certain cases. Like, no person who is arrested shall be detained in custody without being informed as soon as may be of the ground for such arrest, nor shall be denied the right to consult and to be defended by a legal practitioners of his choice. This is the first clause of Article 22, that the person, if detained, shall not be remained detained for long time. He has the right to choose the legal practitioners of his choice to defend his case. So every person, clause 2 says that every person who is arrested and detained in custody shall be produced before the nearest magistrate within a period of 24 hours. Nearest magistrate within 24 hours. This is important. If anybody got arrested, he should be produced before the nearest magistrate within a period of 24 hours, or such arrest exclude the time necessary for journey from the place of arrest to court of the magistrate, and no such person shall be detained in custody beyond the said period without the authority of the magistrate. So Article 22 clause 3 says nothing in clause 1 and 2 shall apply to any person who for the time being is an enemy alien. This is the restriction. This is called the reasonable restriction against Article 22 clause 1 and 2. So subclause A of Article 3, Article 22 clause 3 subclause A and now B, to any person who is arrested or detained under any law provided for preventive detention. And fourth, preventive detention was done at the time of when government of India has removed Article 370 from the Jammu Kashmir, that is special provision, special category provision given to the Jammu and Kashmir earlier. Now that was removed. At that time, that was the preventive detention at that level. So no laws providing for preventive detention shall authorize the detentions of a person for a longer period than 3 months unless an advisory board consisting of a person who are or have been or are qualified to be appointed as Judge of High Court has reported before the expiration of the said period of 3 months that there is, in its opinion, sufficient cause for such detention. So, provided that nothing in this subclause shall authorize the detentions of any persons beyond the maximum period prescribed by the law made by the Parliament under subclause B of clause 7, or such person is detained in accordance with the provisions of any laws made by the Parliament under subclause A and B of clause 7. When any person is detained in pursuance of or an order made under any law provided for preventive detention, the authority making the order shall, or as soon as may be, communicate to such persons the ground on which the order has been made and shall afford him the earliest opportunity of making representation against the order. Nothing in this. So when any person is detained in pursuance of an order made under any law provided for preventive detention, the authority making the order shall, as soon as may be, communicate to such persons the grounds on which the order has been made and shall afford him the earliest opportunity of making a representation against the order. So next is, Parliament may by law prescribe that the circumstances under which and the class or classes of cases in which a person may be detained for a period longer than 3 months under any law provided for preventive detention without obtaining the opinions of an advisory board in accordance with the provision of subclause A of clause 4, the maximum period for which any person may in any class or class of cases be detained under any law providing for preventive detention. And clause C says that procedure to be followed by an advisory board in an inquiry under subclause A or clause 4. This is all about the Article 22. In roughly or in a summary manners, you can understand that the person has a opportunity to get legal consultant of his choice if he has been detained, or he should be presented or produced before the nearest magistrate within the 24 hours. These are the key point of the Article 22, and maximum detention can be done for 3 months. These are the key points. Now we will move to the Article 23. Article 23 says that prohibitions of traffic in human beings and forced labor. Now it is also been banned by the government of any kinds of forced labor or trafficking of human beings. So traffic in human beings and beggar and other similar form of forced labors are prohibited, and any contravention of this provision shall be an offence punishable in accordance with law. Nothing in this article shall prevent the state from imposing compulsory services for public purpose, and in imposing such services, the state shall not make any discrimination on ground only of religion, race, caste, class of any of them. There is a simply clear fundamental of this article that no one can enforce a person to do a certain kind of job. But it is also mentioned under clause 2 of article 23 that if government need a person for sake of statehood, then they can enforce a person to serve for the sake of nation's security. Like in the recent time, you can see the problematic situation of Ukraine and Russia. There, in the Ukraine, even the common people has put their contribution in safeguarding the nation against the Russia. So this is the call for nation. Article 23 is clear now. Next, Article 24. 24 says that provisions of employment of children in factory, etc. This article prohibits any kinds of labor the child under age of 14 years. There should be no employment for the children under the age of 14 years. They should gone to the school. That was the right to education, implemented in 2009. So this is the important part of this act. So Article 25, freedom of conscience and free profession, practice and propagation of religion. This article says that subject to public order, morality and health and to the other provisions of this part, all persons are equally entitled to freedom of conscience and the right freely to profess, practice and propagate religion. Nothing in this article shall affect the operation of any existing law or prevent the state from making any law, regulate or restricting any economic, financial, political and other secular activity which may be associated with religious practice. Part B says that providing for social welfare and reforms or the throwing open of Hindu religious institutions of a public character to all classes and sections of Hindus. Explanation is given like the wearing and carrying of kirpan shall be deemed to be included in the professions of the Sikh religion. Explanation 2 is that in subclause B of clause 2, the reference of Hindus shall be construed as including a reference to person professing the Sikh, Jaina or Buddhist religion, and the references to Hindu religious institutions shall be construed accordingly. Next, freedom to manage religious affairs. Religious affairs is subject to public order, morality and health. Every religious denominations or any section thereof shall have the right to establish and maintain institutions for religious and charitable purpose, to manage its own affair in matters of religion, to own and acquire movable and immovable property, and to administer such property in accordance with the law. Next is freedom as to payment of taxes for promotions of any particular religion. So no person shall be compelled to pay any tax, the proceeds of which are specifically appropriated in payment of expenses for the promotions or maintenance of any particular religion or religious denomination. This is the Article 27. Next, Article 28. 28 says that freedom as to attendance at religious instructions or religious worship in certain educational institutions. Here, Clause 1 says that no religious instruction shall be provided in any educational institution wholly maintained out of state fund. Article 28, Clause 1 says that there is no religious instruction provided in any educational institutions which is wholly maintained by the state fund. Clause 2 says that nothing in Clause 1 shall apply to an educational institution which is administered by the state but has been established under any endowment or trust which requires that religious instruction shall be imparted in such institution. It means that in Clause 1 is completely ban on any kind of religious education where the state fund is used to maintain an institution. But in clause 2 says that if educational institution is administered by the state, not maintained through the state fund, but maintained through the capacity of that trust, and if that trust think that they need to impart some kinds of religious instruction, they can do. This is mentioned under Article 2. Under Article 3 says that Clause 3 says of Article 28 says that no person attending any educational institution recognized by the state or receiving aid out of state fund shall be required to take part in any religious instruction that may be imparted in such institution or to attend any religious worship that may be conducted in such institution or in any premises attached thereto unless such person or if such person is minor, his guardian has given his consent thereto. This is mentioned clearly in clause 3 of Article 28 that if any person don't want to follow the religious instructions given in a particular institution, he can not be enforced to follow that instruction. As in comparison, not following like that of some peoples don't follow kind of national anthem etc. but they stand by near the place of institution, that is their free will. So nobody can enforce them to do such kinds of activity. So next is Article 29. 29 says that protections of interest of minorities. There is proper kinds of protections of the minorities of the country. Any section of the citizen residing in the territory of India or any part thereof having a distinct language, script or culture of its own shall have the right to conserve the same. It means that if any kinds of peoples, some kinds of peoples or a group of peoples are residing in the country have a different kinds of language, scripts and culture, they have a proper rights and they have a complete right to conserve that proper language, script and culture. So no citizen shall be denied admission into any educational institution maintained by the state or receive aid out of the state fund on ground only of religion, race, caste, language of or any of them. So this is clearly mentioned under Article 29. Now Article 29, after there is Article 30. Right of minorities to establish and administer educational institutions. There is a fundamental right given to the minorities to establish their own educational institution and administer that educational institution, as in all minorities, whether based on a religion or language, shall have the right to establish and administer educational institution of their choice. Article 30, Clause 1, Subclause A. In making any law providing for the compulsory acquisition of any property of an educational institution established and administered by a minority referred to in Clause 1, the state shall ensure that the amount fixed by or determined under such laws for acquisition of such property as would not restrict or abrogate right granted under that clause. And clause 2 says that state shall not in granting aid to educational institution discriminate against any educational institution on the ground that it is under the management of minorities, whether based on religion or language. Article 31 says that compulsory acquisition of property. One of the most vexed right is the right to property, and this right was given by the Constitution in order to let the people enjoy their property in smooth manner. But Article 31 enabled the government to take away the property when there lies a legal authority. The 44th Amendment of 1978 deleted the right to property from the list of fundamental rights. After that, Article 300A was added to the Constitution, and that states that no one shall be deprived of his property except by the authority of law. According to the doctrine of eminent domain, the state will acquire any personal property for public use. Property is taken for public use and compensation is paid to the owner. Article 31A says that saving of law providing for acquisition of estate, etc. So this is that notwithstanding anything contained in Article 13, no law provided for acquisition by the state, any estate or any right therein, or the extinguishment or modification of any such rights, the taking over of the management of any person by the state, or the amalgamation of two or more corporate either in the public interest or similar kind of the extinguishment or modifications of any right of managing agent, secretary and treasurer, managing director, director or managers of corporations, or of any voting right of shareholder thereof. Similarly, under the subclause E, it is mentioned that the extinguishment or modification of any rights acquiring by virtue of any agreement, lease, or license for the purpose of searching for or winning any minerals or mineral oil, or the premature terminations or cancellation of such agreement, lease, or license shall be deemed to be void on the ground that it is consistent with or take away or abridge any of the right conferred by Article 14 or Article 19. Next is, these all are the parts of Article 31. 31B says validation of certain acts and regulation. It is that without prejudice to the generally of the provision contained in Article 31A, none of the act and regulation specified in the 9 schedules or nor any of the provision thereof shall be deemed to be void, or even to have become void on the ground that such act, regulation, or provision is inconsistent with or take away or abridge any of the right conferred by and provisions of this part, and notwithstanding any judgment, decree, or order of any court or tribunals to the contrary. Next is Article 31C. Article 31C is the saving of law giving effects to certain directive principles, like under Article 14 and under Article 19, and no law containing a declarations that it is for giving effect of such policies shall be called a question in any court on ground that it does not give effect to such policies. Next is Article 31D. Says that saving of laws in respect of anti-national activity. Article 31D confers special powers on Parliament to enact certain laws in respect of anti-national activities. It is considered that these powers of Parliament to make law for dealing with anti-national activity and anti-national associations are of sweeping nature and are capable of abuse. Next is Article 32. Article 32 says that remedies for enforcement of right conferred by this part. There are some kinds of remedies, or you can say that this is called the judicial review under Article 32 in the Supreme Court. The right to move Supreme Court by the appropriate proceeding for the enforcement of the right conferred by this part is guaranteed. The Supreme Court shall have power to issue directions or order or writs, including writs in the natures of habeas corpus, mandamus, probations, and quo warranto and certiorari, whichever may be appropriate for the enforcement of any of the right conferred by this part. So, these are some kinds of parts of the Article 32. A. That constitutional validity of state laws not be considered in proceeding under Article 32. Article 33 says that power of Parliament to modify the right conferred by this part in their application to force, etc. Parliament may, by law, determine to what extent any of the right conferred by this part shall, in their application to the member of the armed force, or B. the member of the forces charged with the maintenance of public order, or the person employed in any bureau or other organization established by the state for purpose of intelligence or counterintelligence, and the person employed in or in connection with the telecommunication system set up for the purpose of any force, bureau, or organization referred to in clause A to C be restricted or abrogated so as to ensure the proper discharge of their duties and to maintain of discipline among them. Then Article 34 says that restrictions on rights conferred by this part while martial laws is in force in any area. Notwithstanding anything in foregoing provision of this part, Parliament may by law indemnify any persons in the services of the Union or of our states, or any persons in respect of any act done by him in connection with the maintenance or restorations or order in an area within the territory of India where martial law was in force, or validate any sentence passed, punishment inflicted, forfeiture ordered, or other act done under martial laws in such area. Article 35 is legalization to give effect to the provisions of this part. Notwithstanding anything in this constitution, that parliament shall have and the legislature of the state shall not have power to make laws with respect to any of the matter which under clause 3 of article 16, clause 3 of article 32, article 33, article 34 may be provided for by law made by parliament, and for prescribing punishment for those acts which are declared to be offence under this part, and parliament shall, as soon as may be after the commencement of this constitution, make any law for prescribing punishment for the act referred to in sub-clauses 2. Any law in force immediately before the commencement of these constitutions in the territory of India with respect to any of the matters referred to in subclause 1 of clause A of providing for punishments for any act referred to in subclause 2 of that clause shall, subject to the term thereof and to any adoptions and modification that may be made therein under Article 372, continue in force until altered or repealed or amended by the Parliament. So, in this article, the expressions law in force has the same meaning in Article 372. So, dear students, this was the complete video on Articles 12 up to 35, that is fundamental rights. If you like, you please subscribe our YouTube channel, share video, like this video. Thanks to watch this video.